Good morning, everyone. Welcome to our webinar on pregnancy and how to manage it. So we're going to go through different slides. Admittedly, there'll be some questions. If we can save questions till the end, and then we'll try and answer as many as possible, time dependent, but some of them will be answered throughout the presentation. So if you could potentially save them till then, you might find that you have the answers. So if we start with the agenda, we're going to look at the current legislation, the Employment Rights Bill, some of the changes that are going to happen. And bear in mind, although we're informed that we're pretty sure 90% of these are going to go ahead come April, it may change because we've still got a month and a bit to go. But we're going to look at how to prepare because that's not really going to change. And we're going to address what you should be doing for the during the mat leave and the post mat leave, and what is allowed, what's legally required in order to put you in the best shape for managing said absence. And then, like I say, there'll be a Q&As at the end. For those that don't know me, I'm Ciaron Armstrong. I'm the employment law consultant here at Nito's Partners. I advise a plethora of clients, and generally you have your own advisor, and some of your key questions centered around specifics, I would naturally gravitate towards you seeking that advice from your advisor, because there's loads of little nuances and finer points that would change this generic overlook of how to deal with it. So if we look at the current legislation, so it's covered under the current Employment Rights Act, but there's due to be some changes with anyone that's heard any parts in the news around the Employment Rights Act that was passed in December of just gone, and some of those that impact the topic of conversation today will come through in April and put some new protections against dismissal for pregnant women or those taking or returning from statutory maternity leave. The whole act aims, and you've got to think that the government is acting on thousands of industries for thousands of businesses and trying to put a blanket on it. And that's why it keeps some things quite vague, but other bits are quite clear on the obligations on an employer and what they need to do and the protections that are in place for those people taking that leave. Other changes that the government feels aren't required imminently as part of the Employment Rights Act, they'll be phased in over the next year or two, and it's to keep an eye out. Generally, there will be employment law changes in April and in October normally, so we'll just have to look out for them just in case there's anything that impacts our current policies or our current ways of working or current statutory rights and payments and things like that. So we start at the very top with the flexibility. Now, this is underrated and is required with any employee that's informing you that they are pregnant or their partner's pregnant and what's required. Naturally, we're not really going to touch on the parental side from a man's point of view, but if they let you know, then generally you don't need a risk assessment because they're not the one carrying the baby, naturally. But an employer requires a risk assessment, and this is detailed as soon as possible when the employee has told the employer in writing of the pregnancy. Naturally, as operations go and as different industries work, sometimes it's not always put in writing, and that shouldn't be the staple from this statement. It's when you're told, and we couldn't deny that you've not been told if it's crystal clear and there's been a MAT B1 form presented, whatever it may look like. So I put a little note that informing the employer in writing can take many forms because we know how today works and everyone on their phones and WhatsApp messages, emails, a letter, a Teams chat. It could be something as simple as it's discussed in an open forum in an open office, and therefore there are other witnesses, so you have been told. At that point, you need to look at addressing the situation and providing a risk assessment. If the employee has told you very early on in the pregnancy stage, within that 10 to 14 weeks when they've had the first scan, and it's potentially considered safe for them to then break that news because there's less risk of losing the baby at that point, then you should conduct a risk assessment where reasonably practical. And a risk assessment might not carry much risk at that point in time because not much has changed for them. There might be a little bit of morning sickness, but still addressing the points. And it needs to be a rolling working document, and it needs to be reviewed either at a regular time frame that seems agreeable by both you and the employee for the various stages of pregnancy, or I would always have it detailed within that risk assessment. It'll be reviewed on X date, and let's just say 4 weeks in the future. Or if anything changes and the employee comes to you and identifies that there's a further risk because something has changed with them, and we just need to be reactive and flexible around it. The right to time off for antenatal care and appointments. We actually get a lot of queries around this, and what does the law state on what the right to time off is? And it's generally depicted as a reasonable amount of time off to attend appointments. We can have policies in place that strictly say we require appointments to be taken where practicable on days off to avoid unnecessary interruptions to the business. But again, that's not always possible, and a lot of it is outside of the employee's control and dictated by the doctor, the GP, the nurse, whatever that might be. But if you were to have a conversation and say, generally, when we've dealt with pregnancies before, we feel that 3 to 6 appointments is generally a normal amount. I say normal. There's no normal, but let's just put a figure on it for the sake of it. And you have that discussion with them, and it's documented. And you say, right, which hospital are you attending? Oh, I'm attending St. Luke's. I don't even know if there is a St. Luke's. I'm just making it up. And it's 45 minutes away from the workplace. So we need to factor in that it's a 45-minute drive. There could be traffic. Let's call it an hour. So that's an hour there. It's an hour back. An appointment, generally, if we allow for waiting times, let's suggest it's 2 hours. So we would agree with the employee so that when you go for an appointment, if it's during work time, we anticipate it being 4 hours. If you can try and get appointments at the very least at the beginning or end of your working day, so it stops the disruption of work, then we're more than willing to help support that. But they do have the right to be paid for that time. So having it pre-agreed, brilliant. You've done the first steps, but being wary that you may need to be flexible around it because some of it is outside of their control, and this can be quite upsetting for employers thinking, why do I have to pay them? They said it was 4 hours, we agreed 4 hours, but they've taken 6. We kind of have to take that one on the chin, unfortunately. If it's a pattern and all of a sudden there's more and more appointments and they're on a weekly basis, we can push back, we can ask questions why, because it's only the appointments that have been required from their physician, from their doctor, whatever it may be. If the employee themselves wants to take up some baby yoga, that's kind of a choice that they're making, and that wouldn't be classed in this right to time off and therefore wouldn't be paid. But the conversation is key around what appointments they've got booked, whether they foresee having any more. And naturally, that's a really hard one because nobody has a crystal ball to know that I may need an additional appointment because I've got some complications. And again, that's where keeping contact with your advisor can really support in all those nuances of that specific situation and how you can move forward in supporting the employee, but the right way and with your legal obligations covered. Anyone that is pregnant does have a protection from unfair treatment, and this comes in a plethora of forms. Unfair treatment is someone's 6 months pregnant and there's going to be a job role opening up in 2 months' time, and it's the line manager of that employee you still need to tell them about it. They still need to have a fair application and a fair bite of the cherry of going for that job, even if that job is going to start while they're on maternity leave. It doesn't mean that they cannot apply. Whether they're successful or not is a different matter, but if they are unsuccessful, it cannot be a reason because they're going on maternity leave. And again, seek advice on that one, because that can get very tricky very quickly. So bear that one in mind. And maternity planning. Now, this is something that I always advise clients on. The first port of call, once they're told that an employee is pregnant, risk assessment. So take that away if nothing else. Risk assessment needs to be done. But then why would you not look at planning as far as practical with what is going to happen? So at what level are they pregnant? Are they 12 weeks? Are they 20 weeks? What stage are they at? What's their current health conditions been like? Do they need some support? Do they need reasonable adjustments? What appointments have they got planned within the next 8 weeks that we can factor in and start working around now? Has the MAP B1 form been included, or when are we going to receive that? The expected week of childbirth, which is generally covered in the MAP B1 form, but again, you can ask that question should you need to in order to get the pre-planning. We'll go more onto maternity planning because there's a slide on it later, but very important for that transparency and for knowing how you're going to manage things moving forward. If we look at the family-friendly pay, so I've covered this from all bases of the family-friendly leave and pay, and as you can see, they're all pretty much the same. The statutory maternity pay, statutory paternity pay, shared parental pay, and the neonatal care pay. Generally 187, 18 pence, or 90% of the employee's average weekly earnings, whichever's lower. But they come with differing times. Paternity pay is only available for 2 weeks in blocks of 1 week. So it can either be 1 week with then coming back to work for a week and then having another week, and that's their 2 weeks of leave done. Or the maternity pay, which we all know because it's well documented, can be up to 52 weeks. But the pay side, 52 weeks of leave, we should say, the pay side of it is only for 39 weeks. Generally, it's accepted. If someone's taking maternity leave, it would be for the 52 weeks unless they tell us otherwise. Then we've got the statutory shared parental pay and leave, which is where a couple can pool the leave that they've got available into 50 weeks shared between them. And that takes many different forms, where the parent giving birth could take 20 weeks off. Then because of the financial situation, because of the job role that they're in, because of that person's want to go back to work, they go back to work, and then there's still 30 weeks of leave left that maybe the partner then takes 20 weeks to stay at home and look after the newborn, and then there's a further 10 weeks to divvy up. And it's really important, if someone is taking shared parental leave, that you get in touch with your advisor, because the planning gets a little bit more intricate and does need a little bit more detail. Statutory neonatal care leave and pay recently got changed last year and can be up to 12 weeks for that initial care when a baby is born and is requiring some specialist treatment. Again, details of that, seek advice at that stage, because there's a whole host of additional documentation and it can get quite sensitive, because naturally someone's just given birth, the baby's not I wouldn't say not well, but in need of some additional care, and we want to support employees, and we absolutely want to avoid any discrimination from that. So looking after that point is very important, and each case is dependent on its own merits, and make sure you've got a neonatal care policy would be testament to how you would manage that situation. While we're on the topic of family-friendly leave, it's worth mentioning about statutory sick pay. And you're like, well, what's sick pay got to do with it? Well, generally you find that there'll be higher rates of sickness for someone that is pregnant. And that's purely because the body's going through a whole host of changes, and we want to make sure that they're supported and they're aware of what they've got available to them. So if they were sick for any reason, generally, again, well documented that sick pay, as it currently stands, is £118.75 per week, and there's 3 waiting days, 3 non-paid days before they start to get entitled to statutory sick pay. That's looking to change in April, and that's looking to become a day one right. But until that gets confirmed, we're going to go with the current reality of that's what it is. It's available for 28 weeks. So someone can be off for 28 weeks. There's a common misconception that it's 26 weeks, but it's not. It's 28. I don't know why. It doesn't fit nicely into half a year, but that's the government for you. Now, one thing that a lot of employers aren't aware of, or it's there in the back of the mind and they don't think about it, but if an employee is becoming a little bit unwell towards the end of the pregnancy, so the pregnancy is 9 months, and with all the will in the world, the employee wants to stay on for 8 months and 3 weeks. But if they were to get sick 4 weeks before that planned maternity leave, then at the employer's discretion, you can tell them that we're going to automatically trigger your mat leave starting now. And let's, for argument's sake, say it's the beginning of that 8th month, they can start the maternity leave and they wouldn't be entitled to the SSP because you cannot get paid SSP as well as maternity pay. So then they would start the maternity early purely because the sickness depicts it that they cannot attend work. So therefore, we're going to start the maternity. Then we've got the statutory maternity adoption pay. Again, same rate at 187.18, whichever's lower. Again, subject to change come April with natural increases that will happen through the government changes. If we look at the big one, now pregnancy falls into a category of a protected characteristic. We want to make sure that at all costs we've avoided discrimination, because sometimes it can happen unknowingly, and the employer needs to show that it's taken the proactive steps to prevent it. And I've got some slides later that are going to go through the practicality of how we do it, but it's how you take those proactive steps and how you make sure that your policies and not just the policies, because that's wording on a page, but the practices that you actually do and how you operate during that are all up to date and compliant with legislation. Checking through your handbook, it falls into generally your family friendly rights, what policies you've got under that, any flexible working that is a day one right for any employee, but we'll touch on that again later. And again, around the protection of redundancies, which has just been highly protected for people on family friendly leave and those coming back from it, and any changes that the government's going to make come April. Now, obviously, part of this webinar is to help provide training to your managers. Hopefully, there's a lot on the course today that can take a lot away from it, and specifically looking around the protections within the Equality Act, which is again with these protected characteristics, and making sure that we don't unknowingly discriminate or put them at a detriment through what we're doing as our actions. Then we go back to conduct, regularly review the pregnancy risk assessment, because we've put it in place and it's not a document that we fill in. This is our risk assessment, and the employee might only be 10 weeks pregnant. We don't then just put it on the side, file it away. Yeah, job done. Well done, guys. It needs to be a rolling document because it's always changing for them. And we have to have it at the forefront of our mind that we always want to address the changes and look at supporting them any way we can as the pregnancy becomes from what would be considered a lower risk stage of the 10 to 14 weeks to a little bit more higher risk when they come into the end of it. then part of the way of preventing discrimination is having constructive conversations. And conversations goes beyond someone talking, someone listening. Documentation is key to make sure that we have as much information every step of the way to show what we've done. Now, I've put on a semi-regular basis, but again, it can be instigated by employer or employee. If you've set a review time for 4 weeks, then stick to that 4 weeks, unless the employees come to you sooner and they want to have another conversation around how things have changed. So it goes back to that flexibility, but it's also making sure that when you set something down on paper, you've documented it, sticking to it, because that's what the employee expects. Which goes on to the next point, the clear expectations. Now, specifically, this is around the amount of leave for antenatal appointments, what's considered reasonable time off, what should be covered as appointments, and having that conversation prior, having it documented. What appointments have you got within the next couple of months? At which point we are organising and we are planning the next couple of months. And then at which point we're going to have a review, 4, 6, 8 weeks, whatever that might be. And then we'll look at the next couple of months. And you're constantly rolling, and at each point within that meeting, you're moving forward with your planning. You can always bring the risk assessment into that to see how that's changed, if it's changed at all, and what you need to do, while discussing that what we deem reasonable time off for an antenatal appointment is that 4 hours. And that's what we're expecting to pay for it. And let us know if anything needs to change around it. That's what you're covered for. If you set those expectations early on, then it's less likely that an employee is going to abuse the system and have an appointment at 10 in the morning, which you would think it's unreasonable to expect him to attend the office for 20 minutes, half an hour, to then have to leave for the appointment. So they won't be in the office in the morning. Then they've got a 10 o'clock appointment, and then you get a message from them at 3 o'clock in the afternoon saying, I've just finished my appointment. There's no point in me coming into the office because it's going to take me an hour to get there, maybe more in traffic, to spend an hour in work to then go home. I'll just take the day off. You're open to that abuse of the system. Abuse is a bit of a strong word, but you're open to that if you've not set those expectations beforehand. So being clear, documenting it, having the conversation. We'll touch on that again later. The neonatal leave, again, with the changes, there's a couple of slides on this, and it's just to highlight where the importance is that this has come into play. And there hasn't been much case law where someone's been taken to a tribunal because they've been in breach of their neonatal leave, because it's still quite new. And you've got to think a tribunal can take up to 2 years because this law came in last year. We've not seen much of it, but it will be high on the agenda. So a parent can take neonatal care leave for each qualifying week their child spends in neonatal care. What that means is that if the child is born and they are premature and they have to go into an incubator, and they're then kept in the hospital more than what would be an ordinary case. And if they're kept in the incubator for 3 weeks, you've got to weigh up that 3 weeks that new parent that is just getting over a life-changing birth has to go into the hospital or stay in the hospital themselves for 3 weeks. That's almost stolen 3 weeks away from their maternity leave, that time that they have to spend and enjoy with their newborn. So then they get to claim that back with neonatal leave. Of course, there's paperwork around it, and they need to provide that the child has been in that care, and it can be quite sensitive and quite distressing for the parent themselves. So discussing it, making sure that things are crystal clear, making sure that you've got a neonatal policy in place so that you can not only adhere to that, but direct the employee so they know what they're entitled to as well. It goes on that it's a day one right. It has to be taken in weekly blocks. And there are certain notice requirements from the employee in order to let you know. And what we mean by that is that if you're not told that the child has gone into neonatal care and it gets to the 50th week of the maternity, and then the employee brings it up and says, "Oh, my child was in an incubator for 3 weeks at the start, so I want to take those 3 weeks at the end." That's them not complying with giving the reasonable notice, and it can be refused at that point. But again, please seek advice, because we would probably never advise to not give it, but there does need to be the evidence around it. Then, just regards neonatal, employees have the right to return to the same job, or in circumstances to return to a suitable or appropriate alternative job, and it should further stipulate on no less favourable terms. So similar money, similar days, similar hours, all the rest. We look at the statutory neonatal care pay. Again, I know this is about pregnancy, but this still falls into that category, and it's one that does need readdressing because not all employers are aware. So as it currently stands, again, subject to change come April, that the employee has a qualifying period of 26 weeks of continuous service. So if the government gets their way, they're going to change that. It could potentially become a day one right. So potentially that's one for now, but subject to change. The employee must have received normal weekly earnings for a period of 8 weeks, ending with the relevant week of not less than the lower earnings limit. And you're thinking, Ciaron, that's a load of jargon. Again, seek advice where needed, because it does become quite intricate and detailed on what we need to do. And should they be on the cusp of any of these notice periods, any of these they've not served 26 weeks, they've served 25 and a half, we'd probably say, well, let's not add risk or add fuel to a fire. Let's just allow them what they need to have. Again, it's paid at the same rate as all the family friendly rights, £118. Again, going to go up ever so slightly come April. It could be paid up to a maximum of 12 weeks. And it says it's payable within the first 68 weeks after the child's birth, because normally when the government has written the legislation around this, maternity pay that's available for 52 weeks, the parent might take those full 52 weeks. They may have told you and given all the notice about the neonatal care that the child has been in, but they may not have a decision that they want to make about taking neonatal care pay or leave until the maternity is finished. So it might be that they tell you 52 weeks. No, they've told you before, but they may confirm, I'm going to take some neonatal care after the maternity leave has ended. And that's why it caveats it to say that it's within the first 68 weeks of the child's birth. Again, complying with notice periods. Employees who are taking or have recently returned from neonatal care leave are again offered the same alternative of employment, are protected from some redundancies, and have priorities to other employees, which we'll touch on as well. So what does this all mean for you? So there's changes in the pipeline that are going to happen, as I said at the beginning, over the next kind of couple of years, and they're going to be drip fed in to test the water and push back on government. And is this really going to have the aim that it's supposed to do in the protection for employees that take this leave? So what you need to do is covered in blue, because it's a must. Where somebody has a protected characteristic, which in this instance is the pregnancy, you need to make reasonable adjustments. And in law, sometimes it says you should do something, or it would be expected that this would be done. Those are caveat words to let you know that it's not an absolute must. Reasonable adjustments for protected characteristics is not an if, a but, a maybe. It is an absolutely, you need to make them. So that's where the documentation comes in. Where someone requires additional breaks, you factor that in, but you don't just factor it in the practice of allowing them the additional breaks. You make sure that you've had the meeting with them, that constructive conversation, and you've documented that they have made it crystal clear they're really suffering with morning sickness and may require time away, and we're willing to allow that. And they're just to keep us up to date, and it's been readapted into the risk assessment, updated that this is what's required. That's you making a reasonable adjustment, but not just the practice of doing it, documenting it should you ever need to. Assessing the ever-changing needs during the pregnancy, again with the rolling risk assessment, and the appointment days and flexibility. So we've discussed appointment days, what they look like, how they're paid full pay for that time, what is that time as a reasonable amount, being flexible around it, and having the understanding that you've put a plan in place and you've covered the first 2 months, and these are the appointment days. It could change. A doctor might get sick, and then there's no other acting physician that can deal with them because you live in a small town and there's only that one hospital with a few doctors, whatever it may be. So you do need to be flexible, and just making sure things are documented doesn't mean that they can't change, but when they do change, you document them as well. And then we look at the redundancy protections around people taking said leave. So now we're going to move on to the practicality of what you should do, what is considered best practice, and then we'll run through a little bit more detail on it. So as soon as you're made aware that one of your employees is pregnant and they've given you notice of it, the risk assessment needs to be done. Now, excuse me, if they go into the office on a Wednesday and the line manager's not there, and they tell a more senior person, I'm pregnant, great news, and then all the congratulations, that's amazing. It doesn't mean the risk assessment needs to be done there and then on that day, but having a conversation to say, right, well, your line manager normally does the risk assessment side of things because they know your workload and your capacity and what you're able to, and your line manager's currently not in, they're on holiday, they'll be in next week on Thursday, 8 days later. So would it be all right that we do the risk assessment there? And the employee says, yes, that's absolutely fine because I'm not struggling with anything at the minute. It's not urgent. I don't mind. What you should then do for that senior person that's had that conversation, follow it up in an email. Send an email to the employee, CCing in the line manager, saying we had a discussion today. We looked at the risk assessment need and have stated that it will be done next week on the Thursday. So you've absolutely covered yourself that the risk assessment is being done, it's been talked about, and the first reasonable opportunity is when the line manager comes back from their annual leave. So you've covered all bases, and then making sure that those managers are trained in how to do the risk assessments and how to keep it rolling and review periods and all the rest. Has the MAP B1 form been received? So generally, it's around when an employee kind of gets that form, and that differs from hospital to hospital, but we can't hold it against the employee naturally. They've told us, so that's as much as we need to know at the minute. If there is a delay or there hasn't been a MAP B1 issued yet, or it's been lost or whatever, then the expected week of childbirth. It's quite an important one because we need to formulate our plans during the pregnancy based on when they're expected to go on the leave. So you kind of need to know when that is. Bearing in mind, expected week of childbirth is an approximation. It's quite accurate, but let's be honest, it could be, I think, up to kind of 8 weeks before in extreme cases, and even before that in super extreme ones. And I think at the minute, don't quote me on this, but doctors will allow you to go up to 4 weeks over before they induce you, and depending on, again, the childbirth and the water breaking and all the rest. So again, it requires that flexibility. It's not a definitive, that's an expected week of childbirth, so that's exactly when it's coming in. You need to be flexible around it. One important point that is always a topic of conversation with employers around holidays. What happens with holidays when they're on mat leave? Well, they still accrue them. So if somebody's taking 52 weeks off and they're on statutory holiday entitlement of 5.6 weeks, while they're off for the 52 weeks, they will accrue 5.6 weeks of holiday. It's a fact. It's going to happen. What you need to look at is how you plan around that. So it's April. The new holiday year has just started, providing that you run a holiday from 1st of April to 31st of March. And the employee has told you that they're pregnant, so they're working for 9 months. In that 9 months, they're possibly going to accrue 4.3 weeks of holiday. Let's assume that they take a couple of weeks within that. Then what are they doing with the other 2.3 weeks that they've accrued? And furthermore, what are they doing with the 5.6 weeks that they will accrue while they're off? So we plan this in that they've got 2.3 weeks, they're going to get 5.6 weeks. Do we need to address in one of our conversations that you've got 7 weeks? Do you want to use 3 or 4 weeks of that prior to going on maternity leave? Do you want to save all those 7 weeks and tag them on at the end of your maternity leave so you're not off for 52 weeks, but you'll have to be off for 59 weeks? You know, having that plan in place, having it documented, makes it all crystal clear that there's no miscommunication on what's going to be done and where they're going to be used and how payment is going to be. Because you've got to remember as well that an employee taking 52 weeks of leave, only 39 weeks are paid. So those last 13 weeks of maternity leave, they could be struggling financially. And maybe they want to bring their mat leave to an end and put holidays in. Whatever that looks like, again, the flexibility, but the conversation does need to be had. The appointments, again, deemed what is reasonable, how much should be paid, looking at the proximity to the medical services. All these things are the finer details that we just need to touch upon to make sure that we're doing what we're legally obliged to do, but also that the employee knows what they're allowed to take and what is deemed reasonable by us, by the employer. And then looking at any reasonable adjustments. So again, employee-led, employer-led conversations around what adjustments are needed. Could it be that they require some flexible working at any point? Do they need additional breaks, light duties? And this could change at any time. Anything that you do make as a reasonable adjustment, make sure it's documented. Now, the right to paid time off for antenatal appointments. So a little bit more detail that there's going to be the restrictions in the Employment Rights Act, and we're going to see what that looks like. But as it currently stands, you cannot treat them unfairly and potentially discriminate because of the need to take appointments. Now, I've seen it obviously in my line of work where an employee is taking much more appointments than what you would deem reasonable. But the employer hasn't had the conversation, hasn't set the expectation kind of prior in that risk assessment or pre-pregnancy. So the employee thinks, well, I can take any appointments I want, they're going to be paid, and there's nothing the employer can do about it. It's around setting those expectations, being very clear. I've put the antenatal checkups, which are a standard. Parenting classes. Now, if someone's going to be a parent for the first time, it can be quite distressing. You don't know what's going on. You start questioning everything. You start questioning life, your ability to do any of these things. But at what point is it the employee wanting to increase their own knowledge and better themselves and prepare themselves for parenthood? And at what point is it a GP suggesting it? And this is the clear distinction that if it's recommended by a medical professional, then it would generally be covered in these reasonable appointments. If it's something that the employee just wants to do, then generally it's not. Things like the baby yoga. I don't even know what that is. Sounds loads of fun. But if they're going to that and that's off their own accord, because the gym has just set up around the corner that it's got a baby yoga session and they want to go to it, We would be flexible and we say, absolutely, by all means, because we want to support you. We'd make note of it because it's a reasonable adjustment. But we'd also make note and say, but it's not going to be one that you're going to be paid for. So we're happy for you to finish at 3 o'clock on a Friday and go to your baby yoga, but it's not a paid session, just so you're aware. And we make that crystal clear. Therefore, expectations are set, no animosity, it's documented, and that's a choice that they take. A partner's rights, let's assume that it's a female giving birth and a male partner, they're entitled to attend 2 antenatal appointments. That's all. So if you have that employee on your books, then making sure that it's 2 and kind of no more. Naturally, scenarios are dependent on however it kind of comes about. If they've got a complicated birth and there's more medical appointments than what you would think is reasonable, working around it. If they're giving birth to twins or multiple births in general, then normally there would be more appointments. So you factor that in. Generally, the employee will be able to tell you, well, I've got all these appointments booked, because if we've done everything that we've said prior and we've got a planning in place, they tell you what appointments there are. Appointments taking 6 hours, again, depending on where the hospital is or the doctors that they're visiting and what their appointment time is scheduled for, how long the appointment is, and all the rest. And they're on full pay. So naturally, you don't want, or you don't necessarily want, that additional cost to your business. But where does it lie that you have to for legal obligations, or you can push back a little bit? And those are the bits. Seek advice, and we'll be able to support with anything that you need on those points. So can discrimination be avoided? I think the question is, it should be at all costs, but it's around the bits that you don't necessarily see, and it can be easily avoided. And it's just by following the simple guidelines that we've discussed, the documents, things that are not just done in practice, but put down in writing so that it can be evidenced that we've done everything that we can. So I think we've covered the pre-pregnancy and how we do the risk assessment, again, the MAP B1 form and the planning and all the rest. This is around the planning when someone is taking leave, and you look to always reevaluate the holiday position, looking at how to keep in touch. Forgive my English in this, keep in touch is different to the kit days, which are keeping in touch days, but how you actually communicate with the employee. So they're going to leave your employment for maternity leave and potentially gone for 52 weeks. It is a long time for you to leave an employee without communication. So you need to agree, we're going to be in touch. And naturally, I'm not going to phone you every Monday for an update on working schedules, because that's not what it's for. That becomes kind of harassment and abuse of the system. But agreeing, I want to touch base with you once a month to check on how you're doing, to check if you need anything from us, and to let you know of key changes within the business. How do they want you to do that? Do they want a phone call? Are they agreeing to an email? Is it that you send an email that's kind of less intrusive than a phone call and say, can we pick up a call next week on Monday when you're free? Please give me a call between the hours of X and Y, so that you're keeping in touch. Because a lot of complaints come where an employer just hasn't been in touch with the employee. They're on mat leave. I don't want to bother them. I don't want to be looked to be harassing them. So I've just not communicated to them. But in that time, we've had a summer party, we've had a Christmas party, didn't invite them to either. We had some redundancies, but they're protected, so we didn't bother telling them about them. And there was a promotion that she'd be really good for, but she's on mat leave, so we just ignored it. That falls into discrimination, because you've put them at a detriment and not let them know about things that have been going on. You've not made any reasonable adjustments, and you've not allowed them to be inclusive within the workplace. So it's fundamental, because we do see this mistake a lot on how to keep in touch, how often, what method. And then any plans for kit days. Kit days are a legal requirement of keeping in touch days, and someone that takes maternity leave is allowed up to 10. They're allowed up to 20 if they have shared parental leave, but that's for a different webinar. Let's just stick to 10. Do they know before taking their mat leave or before starting to be away, can they plan so far in advance that they want to take their 10 kit days? Ordinarily, people plan to have their kit days in the last 13 weeks of the maternity leave because obviously they're not getting paid. So coming back to work for a day or for 2 days supports them financially, and it helps almost with a kind of phased return in bringing them back into the workplace, but not too strenuous and all the rest. Do they have that plan before going away? If not, the previous point around the communication is absolutely key, because you want to make sure that the option is open to them. They don't have to take 10, they don't have to take any, but you need to make sure that the option's there. And then having that communication means that maybe after 6 months of them being on maternity leave and you've done the regular check-ins at whatever time frame you've said, you approach the topic of kit days. Oh, by the way, I'm happy you've been off for 6 months. I hope everything's doing great. Have you got any plans on utilizing the 10 kit days that are available to you? And then you've nicely led from your communication, from your check-in, from evidence and everything to your legal obligations of the kit days. Now, this again in itself can become quite contentious. An employee says, yeah, I've thought about my kit day and I want to come in on the 1st of January because it suits me and I've got my mum that is off work and she'll look after the baby. You're like, hold on, 1st of January is a bank holiday. We don't generally work, or we do a half day. That kind of doesn't work for us. You can push back because it's a two-way street and it needs to be agreed and decided between both parties that it's going to have some benefit. It is not simply a day for the employee to turn up as and when they want, unannounced sometimes. It has to be planned in, and it has to have not necessarily an outcome, but it has to be beneficial. There's no point in them coming in for a Tuesday when the line manager's on annual leave, another colleague is off sick, and there's going to be not really a lot for them to do because we've changed the new systems and a new way of operating that they'll require new training on. So it's pointless. So we would say, well, that day doesn't kind of work. What about we look at another day that's more suitable for the business? Again, you can always agree the dates that are needed because it meets both. Again, we go back to the flexibility side. You do have to be flexible, but having it set in stone. If you pre-planned kit days before mat leave, then readdressing it because things change, plans change. Maybe the parenting needs have changed, whatever it may be. So again, flexibility, documentation. Then we look at the post-mat leave changes. And we say changes, and then I put the point, well, surely changes are unlawful. I was like, well, it depends on what they are, obviously, and it depends on who wants the changes and why. So any employee has a right to flexible working, but it does seem to be more prominent when families have life-changing events and they've now got this whole new life that is the most important thing in the world, and they decide that they need to look after them, and that's more important than work, and they're financially stable, so they want to work more flexibly. They make a flexible working request. It falls in line with general flexible working requests, and your policy on that is key on how you manage it, the timing, and all the rest. Again, seek advice, but we do see it more often, and we just need to be mindful that those changes are employee led, and we do have an obligation to listen to them and to look at it. Now, the employee, many of you all know this, the employee has the right to the same job after ordinary mat leave. So ordinary mat leave is classed as those first 26 weeks. And should they only take 26 weeks of mat leave, they need to have the ability to come back to the same job, exactly the same job title, nothing has changed, same pay. But I'm going to caveat that if pay rises have happened while they're on mat leave, they needed to be included in the pay rises, which comes with the communication and bit that we saw previously. But then if they're taking more than 26 weeks, they need to come back to something similar. Now, bear in mind, something similar needs to be justified. If it's not justified, it kind of needs to be the same job. Why is the job changed? But either way, it has to be on no less favourable terms. So that's with all the same terms and conditions, with the pay subject to increases, the hours of work, the type of work generally. That's why it's similar. And again, communications. If these have been maintained throughout, it's not going to be a shock that the employee comes back on day one and say, oh yeah, we've just moved you from that department in marketing over to payroll. It's similar though, because it's within the same building. That's not going to cut it. So being justified and making sure that the changes are for proper reasons, business reasons, that it can be done, but it needs to be similar. And those communications also need to happen. Then we look at the redundancy protection. There is a common myth that somebody on maternity cannot be made redundant, and it's not. The redundancy protection is there that should they be at risk of redundancy while on mat leave, or when they're just coming back, or when they've just come back, the protection is that any suitable alternative is given to them. You know, they're offered that, and that can be their role. There's no applying for it. There's no scoring matrix. None of that. Their protection is there's an alternative role. It's yours if you want it. But again, it's not to say that redundancy can't happen. There's many times where a business is going into liquidation. It's going to cease trading. So you kind of cannot avoid redundancies. So there's no protection there because there's going to be no more jobs. There's no suitable alternative, and therefore a redundancy is that necessary evil. And obviously we'll be really sorrowful around it, but there's no other way. Again, seeking advice on that should you look at it, because in order to not discriminate, you need to be super careful on the protections that are afforded to people on family-friendly leave. Now we're looking at the initial period of the return. And the return for me starts with the utilisation of the kit days. So the 10 days that they've got available. And again, it goes on what I've already suggested, that these need to be a two-way benefit for both, and not random days. I think that's kind of crystal clear, but not turning down the request for a kit day just because you don't want to. It has to be justified. Then we look at the holidays. So we've already pre-planned it. We've done it before they've gone away. We've kept the communication while they've been off. So we know exactly what holidays they've still got accrued and what are they tagging on at the end. And it should be no surprise to either party because we've had those communications all the way along the line. We look at something, it's not really common. I've put it's uncommon, but it shows the reasonable adjustment in, does the employee need a phased return? Tactically, the kit days are a phased return. They are 10 days to spread across numerous weeks in order for them to come back in, to meet new faces within the business, to look at any retraining that's needed, to build up their own resilience because they've not worked for potentially a year. So that's there, but sometimes an employee can request a phased return. Can I just come? And it's not to be misinterpreted with a flexible working request. It's, can I build up my resilience by coming in 3 days the first week, 3 days the next week, 4 days, and then build up to 5. And then you'd build up that phased return, bearing in mind the conversation would be, absolutely happy to make that reasonable adjustment for you, but you will only get paid for the days that you work because you're doing a phased return. So you get paid for 3 days that week, 3 days next week, and so on and so forth. Then when they are coming back, is a return to work meeting relevant? And I've kind of asked the question, but I'll answer it for you. It is. They're coming back after a sustained period off. So why not have a return to work meeting, much in a similar format that you would do for someone that's coming back from any sort of sick leave? And I think it's relevant because you need to update them on anything that's changed over the year. Granted, you're going to argue with me, but we've kept up communications and they know everything. Yes, they do. but that's why it's just a refresher. You remember we sent you that email there, and we talked about this, and we discussed about this opportunity that was available, and you didn't apply for it while you were off. This person's been appointed; they will now be your line manager, whatever it is. It's no new information, but it's you again documenting, backing up everything that you have done to make sure that you haven't left them out in any way, shape, or form. And then the last one's more of a best practice of having check-ins with them. I've put regular intervals every 4 weeks, but it depends on the type of business, the type of industry that you're in. But it's just making sure that they're comfortable in that return to work and checking that everything is running smoothly. And therefore, you've done everything pre, during, post to make sure that you've not discriminated in any way, you've supported every way possible, and the employee's happy in their return to work. Then we're touching on, what to do in the event of a flexible working request. So it's dealt with in the same way as anything else kind of would in the flexible working policy. You review your policy, you look at the timings, again, this is based off today's legal requirements. Again, subject to change in April. You're going to get sick of me saying that. But flexible working policy, they have to put the request in writing. You then have 8 weeks to respond to it. And generally, you have to have a meeting with them to discuss the changes that they want and why they want those changes. And if you have any alternatives that you want to put forward that work better for the business. And it's kind of a negotiation on what works for you, what works for them. Can we find some common ground? But currently, you have 8 fair reasons that you can deny a flexible working request. As you can see from 8 of those, none of them refer to you just coming back from mat leave, therefore we're going to deny it, because that would be discrimination. It's these 8 fair reasons. Now, where would the denial lie? Well, it's not extra costs, because we've planned every step of the way. So we know that they were coming back, and any extra cost to them coming back onto the payroll full time is more on the employer's lack of planning rather than the employee. So that's null and void. The work cannot be reorganized. Well, same as above. If you've not planned in that you've got someone on temporary maternity cover that will be ending as soon as that employee comes back, then why can't you reorganize kind of the other staff or make adjustments? People cannot be recruited to do the work. Again, dependent. If they were in a very senior position and doing 5 days a week, can you redistribute things? Again, there's arguments 2 and 4. Can we not utilize that as a great opportunity to develop some other people? But again, flexible working will affect the quality. Well, you don't know because they haven't been there for 52 weeks potentially. So how will it affect it? How will it affect the performance? Again, you don't know. Business not able to meet customer demand, depending on if you're customer focused business. There's a lack of work to do during the proposed working times. That's more relevant if they're on a 9 to 5 and they say, well, I actually want to work from 5 in the evening till 10 at night. No, that makes no sense. That's easily turned down. Again, anything that you're unsure of, seek advice from us, and we're happy to support. The business planning changes to the workforce. Again, they've got protections against redundancy and all the rest. So not necessarily relevant in that case. But in April anyway, the government has discussed around scrapping these 8 fair reasons and making it a lot more difficult to actually deny a flexible working request. We'll see what that looks like. So watch this space. So what are the key takeaways? I must have mentioned it 100 times about the planning. So a maternity planner. I have one that I utilize and I send to clients, and it has a nice easy checklist on there about all these bits, the risk assessment being done within a reasonable time frame. Has the MAP B1 form been received? If not, feel free to chase that up. The holiday usage, because planning that in is all part of it, and it's all covered in this maternity planner, that you have everything that you need in order to make it a seamless transition and to make it as open, transparent, and comfortable for both employee and employer as possible. So the main point, the effective open communication with the employee. And this goes through all the stages. While they're still in work, obviously, that's a lot easier because they're in the workplace. And you can plan as much of it as possible during that time, during the meetings that you're having, but then also with a view to being flexible with the plan as and things need to change. We've discussed the importance of the communication again while they're on their leave, not bombarding them with weekly updates because, let's be honest, they probably don't care because they've got more important things that they're doing. Also, they're on leave. Why would they need all of that information? That's information overload. So making sure that it's clear, it's concise, and it's timely, and it's only where necessary around changes to the business, around inclusion on any parties, outings, extracurricular things that are going on. How and when you communicate that is dependent on that plan that you put in place before they left on leave. Then the kit days, making sure that we've offered them, they are there, available, that suit both parties, and being crystal clear on what that is. And the return to work, that we are assuming that it's after the 52 weeks of mat leave plus whatever holiday has been tagged on. But should the employee want to change it, then the notice that's required in order to make that change currently is 8 weeks. So if they're set to come back for the end of May, they need to tell you 8 weeks before that I kind of want to change that and I want to come back beginning of May. So for now, they've just about covered that 8 weeks of notice. And again, you need to look at it. You need to look at business needs and whether it's something that is agreeable and you can do, depending on their reasons for wanting to change it, and whether you've got someone in and they're on mat cover and they're always expected to end of May. Have we got the clauses in their contract? Should we need to terminate earlier? Do we want to terminate earlier, or is this a great opportunity to use it so that they've got an overlap between the person that's done the mat cover and the person coming back from mat leave? So there's a great handover, and we look at covering the business from all aspects on the return to work and creates a seamless one. But of course, that comes with a cost. So exploring that depends on business needs. So I think that is me in that whistle stop tour. Thank you for listening to me talk at 100 miles an hour. And if you have any questions, please feel free to pop them in the box. And Sol, my colleague, will be reading them out for me and let me know. We'll answer a couple. But then any further ones, any specific ones, we would always guide you towards the advice line. Get in touch with them or giving your advisor a call. So over to you.
Yeah, thanks, Ciaron. That's brilliant. I've got the first one from Nathan Hutchins, who says, does an employee accrue holiday hours during the unpaid final 13 weeks of mat leave?
Absolutely. So they're on mat leave and holiday still accrues. Again, being careful, because if they're on an hourly rate, then it depends on what their contract is. If they've got a flexible contract and they don't work set hours, so 1 week they work 20 hours, 1 week they work 30 hours, this is pre-mat leave, obviously, and the holiday pay is paid as such as an average, then obviously not working or getting paid for those 13 weeks can have an impact on that average. So again, that's specifically one, absolutely speak to your advisor if that's the case, but generally they would still accrue holiday leave. Absolutely.
Sorry, just turn my mic off for a sec. We've got Jennifer Golden. Does the employee need to provide evidence of the antenatal appointments?
Great question. I would always say to a client, it's not what you're told, it's what can be proven. And that's where documentation is key. And I can appreciate it's neonatal and the baby's potentially in a bad way and it could be a really sensitive kind of situation. So my advice on dealing with that would be to send out a kind of email that's non-intrusive and just saying, hi, employee, I'm really sorry to hear about it. If there's any support you need, please let me know. Do you have any hospital documentation for us to hold on file for you? So you've asked the question, it's been handled sensitively. If you don't get any documentation, again, speak to your advisor, because it depends on whether we absolutely just trust the employee and what they're saying and taking it for granted, or whether we want to further investigate it. But is that first week after they've given birth, is that the right time and place to investigate it, or should we leave it for later down the line? Depend on business needs, but great question.
Brilliant. Okay, Sarah James. So to clarify, is the partner having 2 times paid appointments new? That's in regards to the paid.
There's 2 for the partner.
Yeah, yeah.
Is it new? No, it's been around for quite a while. It's not normally something that is very well documented or utilized. A partner taking time off for an antenatal appointment, you'd expect that they would want to be there for the first one to get the baby scan and all the rest, and then they would plan in another one. It's kind of been law for a while. Don't test me on the dates and the year it came in, but it is there and it is available. Kind of has been for some time.
Cool. We've got a double prong question here regarding holidays. So I think this employee or has it's a second job or part-time job. So does the employee accrue holiday hours when this is her second, in brackets, part-time job, as she would already accrue holiday for a full main-time job? And the second part is also with this same employee, where this is a second job, should she be offered kit days? And if so, at what point should we approach her to see if she wants to do a kit day?
Okay, another great question. So holidays, the simple answer is yes. They accrue holidays from any job that they've got. Holiday leave, holiday pay, yes. Because if that employee has a requirement to work 40 hours a week in one job and 20 hours in another job, why would they not get the benefits, the statutory benefits that each job would allow them? So they would have holidays, pay and leave accruing. Then the second part, sorry, Sol, remind me the second pronged attack.
Um, the same employee, this is a second job. Should she be offered kit days? And if so, at what point should we approach her to see if she wants to do a kit day?
Yeah. So naturally in her daily life, outside of the maternity leave, she'd be very busy because she's got 2 jobs. And then all of a sudden she's not got any. And you want to make sure that you're compliant. Kit days absolutely should be offered because, again, they're a statutory right. You offer them. How you offer them is entirely up to you. And you can be suggestive around, I know you're busy and I know that your hours of work with us were generally kind of late at night. We would try and keep it the same in order for you to come back into kind of the workplace. So would you like to do a kit day and it'd be 7 o'clock at night till 9 o'clock at night? Is that suitable? And it's for them to decide at that point whether they want to take you up on that offer or not. But if their full-time job was 9 to 5 and they never worked for you 9 to 5, then it'd be unreasonable for you to offer a kit day or any kit timings between 9 to 5. So it's always sticking within the contract of employment around the times that they worked, but you should absolutely offer them, but then being clear and justified on the times and the days and the reasons why, in order to cover yourself. But yeah, legal obligation, kit days offered.
Okay, I think this is the last one. So, Kaylee, at what point should we be notified if the employee doesn't want to return to work, or if they do want to return, but what change in their days / number of hours worked?
Great question. So the simple answer is we don't know what is going on with that employee while they've been off? What has changed for that? I mean, we know the obvious of what's changed for them, but how has that changed their situation? Has their partner been given a promotion that is then able to sustain the family and they don't want to come back? And that's, again, it falls back into the whole part of the presentation. Looking at your communication, keeping the communication open. You'd like to think that if you've done all that every step of the way and you're in that semi-regular contact, the employee will let you know whether they're not returning or not. And I understand your concern that sometimes they don't and they drop it on you last minute, and then you have to change your plans and your organization around how you cover that. But they can literally do it last minute, and down to whatever's changed in their life, you have to be adaptable and flexible around that. I would always be careful if someone has resigned following their mat leave that we put in a option to reconsider, and we draft a letter for you to say, well, I've got your resignation, but would you like to reconsider it? Take a couple of weeks to think about things, because we want to make sure that it's not a rushed decision based on the here and now of today, but it's something that you give thought to and you speak to your family and all the rest, so that you cover yourself in that. If they were to come back and request flexible working, as it was kind of stated, it's dealt with no differently than any flexible working. So if the employee comes back day one and puts it in writing, I would like to make a flexible working request and go to 2 days instead of 5. They've not given you sufficient notice for you to get organised, and the statutory legislation on flexible working is that you can take 8 weeks to review that. So you're covered from a legal standpoint that you can take the time to review it. If you are always willing to accept it to go from 5 to 2 days, maybe you don't accept it within that first week because you've got some background planning to find some cover. So you can have the meeting with the employee and say, we're mindful that we're going to review it, we're going to look at some cover, but can you stay on your 5 days for the next kind of 4 weeks, and then we'll have a definitive answer for you. Or you can tactically schedule a meeting for them in 4 weeks' time and know that you have to do the planning around that in order to do it, if you're always going to accept it. If you're not going to accept it, then you need a week or two creating a good business plan, currently based on the 8 fair reasons that you can deny it, to say, we cannot support your flexible working request because of XYZ, and it's going to put a detriment on the business. But being crystal clear, transparent, always the best way.
Thank you. That's good. This will be the last question. So we've got Senja. Do we have to offer 10 days to employees who only work 2 days per week?
The simplicity of it is yes. You'd like to think kit days. Oh, well, it's 10 because generally it was made by the government when people were working full time. So someone working part time, can we not pro rata them? I like your thinking, but simply no, we can't, because they've got 2 days per week that they're working, but they're off for 52 weeks. So why couldn't they plan in 1 day a week for the last, I don't know, 26 weeks of the maternity leave or something? It's still options that are available to them, but how you approach that with the employee, because maybe they don't want to utilize 10 kit days. And again, it's that agreement between both parties, what they're going to do while on those kit days, because you can get them back into kind of working if reasonably practical, so that you're getting the added value that you need from those kit days.
Okay, brilliant. I think that wraps things up. A big thank you to Ciaron, who's brilliant and fantastic. He's actually gave you 15 minutes more, but it's very detailed, and I hope everyone found that useful and informative. Just remember, if you're a client, please ring us with any questions, as always. If you're not a client, I'll put the number and an email to contact in the chat, and we hope to see you next time. Thank you.
Thank you, everyone.
Bye.
Have a good day.